Good afternoon and welcome to the OOR's webinar today as our participation in Sunshine Week. We're going to be presenting some basics and updates on the Sunshine Act. And we have George Spiess, who is the OOR's Chief of Outreach and Training. We also have with us as a guest Alexis Wheeler. She's an associate at Tucker Ahrensberg in Pittsburgh. And
actually, Strassburger, McKenna, Gutnick, and Gefsky.
Oh, shoot. my mistake. And she's also the secretary of the Allegheny County Bar Association, the Committee on School and Municipal Law. And I am Kelly Isenberg. I'm a senior appeals officer here with the OOR. And I will be turning it over to George.
Thanks, Kelly, and good afternoon, everyone. Like Kelly said, this is pretty much just a discussion of the Sunshine Act, and I'd like to welcome you also to Sunshine Week. It's not really formal training. If you're looking for that, we do have webinars that I would suggest you sign up for on that. But we will have the opportunity at the end of the session to answer any questions that you might have, specific to what we're presenting here today. Just a quick overview on our experience with the Sunshine Act. The Office of Open Records is primarily responsible for administration of the right to know law, but yet statutorily, we're also tasked with providing training and guidance for Pennsylvania's Sunshine Act. We're not an enforcement agency, and we really have no enforcement authority when it comes to the Sunshine Act, but yet because of our statutory role, we get a lot of questions from folks. Probably, I'm going to say back in 2017, we started noticing a trend with the inquiries that we receive here at the office. And, that's a fairly busy exercise. All day long, people are emailing us or phoning in, and it could be public officials, public employees, or the public in general. And back in 2017, I would say that the metrics were such that roughly 70% of the questions that we would receive involve the right to know law, and then only 30% involve the Sunshine Act. We started seeing a slight increase in the Sunshine Act, enough that I actually brought it to the attention of other senior managers here. And I said, we may have a trend developing. And sure enough, that increase did steadily keep on climbing. And then COVID hit. And probably as a result of the growth of online meetings and much of the subject material that was being covered in meetings, both with municipalities, state agencies, as well as school districts, we started seeing a real spike in Sunshine Act related inquiries. To moving to today, 2022, I think we can fairly say that the metrics are such that 50% of the inquiries that we receive now involve Sunshine Act issues. I think, as a result of COVID, there's been a growing interest in local politics, local governance, especially with school boards. People are concerned over their property taxes. We get questions, or we see questions about curriculum material. With COVID, there was a lot of discussion about masking policies, school closings, the decision-making process, the data used to arrive at decisions, and so forth. And some of those, like we'll show you here, some of those meetings really got quite contested, if you will. And we believe that the solution to dealing with many of these issues is just greater transparency on the part of agencies. Now, we're the Office of Open Records, of course, we're going to say that. But yet, where we've seen it practiced, where municipalities, where school boards really go the extra mile to ensure that the public is brought into the decision-making process, I think the meetings tend to be a lot more cooperative, and you don't see that divisiveness and the shouting that make the headlines. So we recommend, open up the decision-making process. where you have the infrastructure to do it, go ahead and live stream your meetings, record your meetings, post them online afterwards. And really, honestly, both sides need to kind of tone down the rhetoric. You need to start talking with each other as opposed to shouting at each other if we're really going to arrive at, democracy in action at the local level. As we're famous for saying here, transparency builds trust. And it's that trust that truly makes local government work, whether you're concerned about a borough, a township, a city, an authority, or a school district for that matter. So some of the concerns that we've seen recently raised as a result of questions over the Sunshine Act really involve misuse of executive sessions for topics that fall outside of what's legally permissible, deliberation occurring outside of public meetings by public officials, and then finally, unreasonable limitations on public comment. That's what people are calling us, asking about. That's what they're concerned about, as well as questions for instruction coming from the agency side of it. So that's pretty much kind of a summary of where we're at relative to the Sunshine Act. I'm going to turn it back over to Kelly now, and she's going to talk about some specific cases and such.
Thank you. I'm here to present just a smattering of the case updates of what has taken place for the past couple of years. As George mentioned, due to COVID, some of the municipalities and school boards had some difficulties and bumps in the road in adjusting to virtual meetings and making sure that the public was adequately represented. An interesting one back from October in 2020 is McGrath versus the Board of Directors of the City of Scranton and the school district of Scranton. In that matter, there was a request for preliminary injunctive relief because the citizens were not able to fully participate in a meeting in which the board voted to furlough 218 employees and immediately terminate their health benefits. The issues that came about in this matter was it was being broadcast on the Zoom platform, but that was limited to 100 participants. So not all of the citizens who registered to make comments were admitted into the meeting because the meeting hit its maximum amount. It was being live streamed on YouTube. However, partway through, YouTube became inoperable, so those who wanted to view the meeting were not able to view the meeting. And the big issue here was the school board was aware of these technical problems and had a discussion and chose to go forward with the meeting. And they made this decision to go forward with the furlough. Judge Nealon of up in Lackawanna County determined that these were violations of the Sunshine Act as well as the COVID-19 disaster emergency. He invalidated the meeting, he invalidated the decision, and they had to go back and do it again. Another somewhat interesting case that came out of 2020, it was Mid-Mon Valley Publishing Company versus the city of Monessen. If you ever have the opportunity to view the videos of these few meetings, they were very, very contentious to the point that the city council members were yelling at each other, and the mayor, who was on the council, had not been present for any of the meetings for quite some time. He showed up at a meeting, they made a motion, and they made a motion to fire the solicitor, hire a new solicitor, restrict access to only city cameras during the meetings, rescind the appointment of a sewage board authority member and then advertise that position as a new vacancy. So in the next meeting, the mayor moved to ratify those decisions, and that was voted upon, and they were ratified without any public comment. Once again, on March 10th, it was represented and the items were on the agenda this time and public comment was received. While the judge in this matter and the Court of Common Pleas determined that the subsequent meetings ratified and cured any Sunshine Act violations, he determined that the city needed some assistance and mandated that they undergo Sunshine Act training through the OOR. Did they ever sign up, George?
Yeah, they reached out to us, and we had the training one evening with the mayor and several council members. And then we provided a statement back to the judge confirming that the training had occurred. The judge really went, off script with this, and I believe it was couched in the form of a settlement, ultimately. And it just shows the leeway that a judge can have relative to sanctions under the Sunshine Act. And really, I think it represented the best possible solution there, because technically the council had already cured its violation, but yet that didn't take away from the fact that the violation had occurred due to lack of knowledge about what the Sunshine Act required. So I think we had a very good session, and we haven't heard of any issues coming out of Monessen since then.
The next two cases I'm going to speak to, well, one is McKenna versus Jefferson Morgan School District. And this was a U.S. District Court matter that came out of the Western District. And it's not a per se Sunshine Act matter, but I thought it was interesting because it is highlighting the increasing consideration of the citizen's right to speak publicly. In this case, it was a parent of a school student, and kind of exploring the permissible limits on such speech. In this matter, a father was, after several incidents, a father was banned from school sanctioned activities and school grounds because of bullying, intimidation, profanity, and those types of behaviors. The incidents included when he approached the football team and the coaches on their bench after his son was removed from a football game. Another event occurred when he was dissatisfied with the team's performance, and he was using profanity with the superintendent on the way out of the stadium. And then the final straw was when he met buses from the school buses bringing the team back from an away game loss. And he was witnessed by parents, students, coaches, basically pacing around the two buses looking for the coach, and very loudly and profanely calling for the coach's resignation. The takeaway from this is that the court found that the school district acted appropriately. Now, the facts bear out that this was kind of an increasing punishment, a type of scenario, in that they met with this parent more than once prior to issuing the ban letter after that incident with the school buses. And what's important is it's important to have these objective, reasonable procedures leading up to the curtailing of a person's public speech, but also bearing in mind that there are time and place type of restrictions, and a school district's duty to keep the school events and school grounds peaceful and safe. And the final case I'm going to discuss is Marshall versus Amuso. This comes out of the Pennsbury School District. I think it's in Bucks County or Montgomery County.
Montgomery County. Yeah.
Montgomery County. This was a preliminary injunction matter in the Eastern District of PA. That related to the district's application of one of its policies that governed how they can limit speech, comments, etc. at their school board meetings. And we have a short video clip that illustrates how the school board had been limiting such speech over the course of a couple of meetings.
Give me just a second here to bring up the clip. There we go.
So I'm having a little bit of respiratory issues tonight, but okay, so I leave it off my nose. Is that fine? That would be fine. Thank you, Mr. Wall. I'm here tonight to alert the community that I have 12 appeals sitting in Harrisburg, 4 of which I have already tentatively won, with the remaining waiting ruling next month as the board authorizes Rudolph Clark to continue to block access to records that we have a legal right to review. The reason for the defense of these RTKs is because the details that will come forward may be personally embarrassing to members of this board, such as the July 30th email that I now have in my hand that a member of this board actually stated in social media publicly didn't exist. The community should be aware that the district has wasted thousands upon thousands of dollars to create multi-page affidavits to block access to information such as the number of resumes that were submitted for the superintendent position. For community clarification, just 22 resumes were received when the typical job search for a superintendent would generate 200 resumes. Thankfully, we got a great hire in Dr. Smith, but that was through luck, not through the effort of the school board. Most recently, we learned that the board authorized and discussed cease and desist actions against 2 Republican candidates for allegedly violating Board Policy 707.1R5, when in fact no violation occurred. Only a picture was taken by a Corey Hill elementary student of her mom after they finished eating lunch. And I was there, I saw it, it didn't happen. But when a sitting member of this board actually did violate the policy this past Saturday, this board couldn't even display basic courtesy to acknowledge receipt of my complaint. More concerning is the event aimed to interrupt Pennsbury school business for political purposes. It brings the question, did this school board misappropriate funds for political use? Well, I put in an RTK, hoping that we could discuss this in more detail tonight, but once again, it was unilaterally delayed without legal justification. So let me clearly state, our taxpayer dollars are not monopoly money for you to play with. The misuse of legal services by this board needs to stop. Pivoting, I do want to take a moment to remark over the disturbing misconduct by this board during the April school board meeting when members of this board staged a prepared personal attack on community member Doug Belmsham. During those prepared attacks, board members misrepresented facts around equities in schools, presented unindexed statistics that have no reflection on Pennsbury.
You know what, I'm gonna stop you there. We're not gonna tolerate misrepresentation of facts around equity. So that's irrelevant and you can stop.
In your opinion?
No, you can stop, Mr. Daly. You're done.
You sure you want to do that, Mr.
Yes,
President?
I do.
All right, we'll see you in court, sir. Just a reminder, you didn't need an
I said you're done. I said you're done. Mr. Daly, sit down.
The Pennsbury School Board behaved in a similar manner with 2 additional commenters that evening. And this was not the first time this had occurred. Prior to that, when they were still virtual, the school board had been editing comments, written comments submitted and for the virtual meetings if they determined that they were in violation of their policy. In addition to that, the gentleman that you saw on the video at a prior meeting, they had taken down the video of the meeting, edited out his comments until a complaint was made, and then it was posted in full, unedited version. In this matter, a civil action was filed by 4 of the attendees challenging the school board's policy. And following an evidentiary hearing, the court found that the challenged portions of the school policy was overbroad and vague, and that it could not be objectively applied without abridging the commenter's freedom of speech under the First Amendment. The court pointed out that while school boards are limited forums, that content-based restrictions are only valid if they're reasonable and viewpoint neutral. Some examples from the evidentiary record that they pointed out were not viewpoint neutral, were when commenters were discontinued, they were asked to stop because they were being disruptive. But the disruptive determination had to do with an opinion or a viewpoint, not disruptive behavior. In addition, many commenters were directed to stop when the school board determined that their comments were irrelevant. One of the litigants, it was interestingly, was commenting on the district's equity policy that was actually an agenda item at that meeting. The takeaway for this is that the court enjoined the application of the policy. Could you pull up the policy? The policy 903's language, because it determined that it could not be objectively applied, such to not abridge the free speech of the commenters. That the court stated that policies 903 and 922 are vague because they are irreparably clothed in subjectivity. What may be considered irrelevant, abusive, offensive, intolerant, inappropriate, or otherwise inappropriate varies from speaker to speaker and listener to listener. The court granted the preliminary injunction, and the matter has not moved forward at this point in time to determine whether there will be a permanent injunction. The main issue here, a big issue here, especially for the agencies and practitioners, is that this is somewhat common language in school board policies, and that depending on how the agency or the board carries out the policy, it may not be valid going forward, and the agencies may want to review and reconsider their policy language. And I think that's all I have for now.
Okay. We're going to switch over to Alexis, but first I need to apologize. As someone kindly pointed out, Pennsbury is not in Montgomery County, it's in Bucks County. And here I sit with a 5x9 Pennsylvania map right next to me, and you'd think I would have looked at it. But thanks for that information there, and I apologize for my lack of Pennsylvania geography knowledge. Alexis.
Thank you. First of all, I would like to say thank you so much for having me today. My name is Alexis Wheeler, and I am a practitioner out here in Pittsburgh in Western Pennsylvania with the offices of Strassburger, McKenna, Gutnick, and Gefsky. I am a municipal law attorney. I serve as the solicitor for different municipalities, zoning hearing boards, and municipal authorities in Allegheny and Washington County. And, you know, through the pandemic, we've encountered some difficulties with navigating the Sunshine Act, primarily with virtual meetings. And so now that virtual meetings under Act 15 are no longer specifically spelled out in legislation, I have a question for the Office of Open Records regarding whether if the enacting authority for an agency, so for instance, the Second Class Township Code or the Municipal Authorities Act, does not require a physical quorum, are strictly virtual meetings permissible under the Sunshine Act, or should a public building still be open for public participation?
Yeah, that's a great question, and it reflects one that we get here a lot lately. With the emergency declaration expiring, it's our position here at the Office of Open Records that there needs to be some form of physical presence for any public meeting. Now, I think it's the Borough Code and the First Class Township Code require that a quorum of the board be physically present. But the other codes, like you mentioned, authorities and second class townships and not, you won't find that language. So conceivably, you could have a meeting, a hybrid meeting where the board is all virtual, but the public would be in a room. I don't think that's happening much that we've heard of, but in discussions we've had with various members of the legislature, they're rather cautious about having that sort of scenario take place. More than one legislature spoke to the utility of and the appropriateness of being able to have a face-to-face conversation with your elected public official. So it's our position here at the Office of Open Records that at the very least, given the way the law reads, that there needs to be some sort of physical presence available for the public, and more than likely that physical presence would involve at least some percentage of the board being present so that the public can address the board on a face-to-face basis. But again, I want to emphasize that this is purely our position on this. It's our basically guidance. It's nowhere in the Sunshine Act. And obviously we don't have enforcement authority over this act. So, it's a question we get asked, and looking at the law, it's the answer we're providing.
Great, that was really informative. And so my next question has to deal with the new amendment. So as I'm sure we're all aware, the Sunshine Act was recently amended in 2021. And my question goes to, what is the process for adding an item to the agenda if it was not included when published? So for instance, I think that we get a lot of questions concerning the majority vote amendment method. So if the majority of the board members vote to add an item to the agenda, this is a two-part question, I suppose. First, should that item also be de minimis, or is there any criteria for that? And then second, what does the procedure look like that ideally for the Office of Open Records? Would that include a vote to amend the agenda and then a vote on the new action item so that there's time for public comment in between? Or how do you contemplate that happening?
Yeah, unfortunately, there's very little language in the new provisions that provide that level of guidance, but I think you're on the right track, Alexis, with how you would spell it out or how you would envision it happening sequentially. First offhand, let's talk about the time frames. You've got this 24-hour window. Well, any agenda amendments, or I should say any changes to the agenda before that 24-hour threshold hits is open. You can change the agenda at any way you want to. Okay, then 24 hours before the meeting is scheduled to begin, you hit this, what we'll call a window, where you can only change the agenda if it's a de minimis matter. No expenditure of funds and no of entering into contracts. So, what does that mean? Well, that could be somewhat subjective in how you define de minimis, but, I think applying a common sense standard, you'll figure it out. Okay, so then we come up to the point where the meeting is called to order. At that point, we're back to pretty much an open book as to what can be changed, but we would follow the sequence that you detailed. At least in my mind, that's how it would happen. First, you would make a motion to amend the agenda, and it has to pass by majority vote, and it has to be explained to the public why you're amending the agenda. And then once that has all occurred, you would go about with the business on the new agenda item just as you would any other agenda item. However, once the meeting has concluded, the agency then has 24 hours to post the amended agenda. And people ask, okay, well, how long do we need to post it for? Again, the Sunshine Act doesn't say, but given the 24-hour window previous to the meeting, we think a 24-hour window after the meeting is kind of a logical extension of that reasoning. So again, you're not going to find it anywhere in the law. Maybe if a complaint were filed, a judge would disagree with what we're saying. But until that happens, the best we can do is say, keep it posted for 24 hours. And of course, all of this would be reflected in the meeting minutes because it reflects official action on the part of the board. Number one, amending the agenda. Number two, voting, if that's where you're headed, on the new agenda item. So like I said, I think you're on the right track there.
Great. And so I just have a final question that I was thinking about hearing Kelly give her update on the cases that have recently happened in the Commonwealth. And that is, could the OOR provide some guidance, I suppose, on what reasonable rules and regulations might be for public comment?
I don't think that is our role, and it is, I think it's evolving at this point in time as George, when he started the meeting, the role of a school board has definitely changed drastically or evolved drastically due to COVID and the much more personally impactful decisions that they have had to make, by virtue of the circumstances. But I don't think we could. I think you would just have to, probably the Pensbury case would be a good guidance. And in that decision, Judge Prater, I'm trying to find my notes, she emphasized that to make it less overbroad as applied, she did note that the policy 922, which is the overarching policy, not just applying to the school board meeting, but to all the activities of the school district, provides for them to make workable standards to carry out these policies. And that was one aspect that Judge Prater noted, that the school district had not done that there were no objective workable standards, and that the discretion was in the hands of whoever was in charge of the meeting at that time. So that risks bringing in their individual bias. And also that it's an even application. Like one example was that folks were told to discontinue their comment when they were giving their opinion on the equity, the new equity policy and agenda that they were, not the agenda, the curriculum that they were trying to enact. But the commenters that agreed with the new curriculum and wanted it in effect were not similarly stopped commenting for their viewpoint. So that's where it gets a little kind of biased in its application. So I would say make sure it's applied evenly, and if an entity can somehow publish or work up objective standards on how these are carried out and who exactly gets to determine there's a violation, that would be helpful.
Yeah, I'll jump in too and add to these excellent points in that when I first saw the video and then looked at the policy, what I find problematic, or what I found problematic, is how it conflicted with language in the actual act concerning public comment, where it says public comment can be for matters that are or may be before the board. And that word may in there is problematic because the school board policy attempts to narrow the scope of what public comments can be. And that was the whole point in the video. You know, the language that you're using indicates that your comments are irrelevant. Thus, you're done. You are not going to allow you to comment on irrelevant topics. And, you know, that's an argument in itself with that specific situation. But when you look at that language in the act and the presence of that word may, it is definitely in conflict with the policy and its intent. So it doesn't surprise us at all that a judge ruled in the way that he did. But, you know, you ask a very hard but yet very relevant question. You know, what is or what are reasonable standards for governing public comment? And it can be difficult, but I think where we're at now is that as long as you're not using profanity, as long as you're not personally attacking people, it's pretty much an open book. And I think it's going to come down to the ability of agencies to foster a productive relationship with the attendees during the meeting. Now, obviously, that's a lot easier said than done. But, you know, once we get back to working all in the same direction, even if we disagree, you know, we can still respect each other's right to voice our opinions and hopefully, you know, get back on track with all of this.
Great,
And
thank you.
a couple of other interesting notes right from Amuso, dovetailing on George's comments, is that this particular school board opened up comment for agenda and non-agenda items. So how could it possibly be applied in a non-biased way by having a member saying that your comments were irrelevant, but it was open to non-agenda items? And another matter pointed out by the court is that comments may be personally directed, but not in violation of the policy if it relates to business of the district. For example, I'm criticizing a district employee for incompetence or possibly wrongdoing, and that is, you know, that is a matter that is district business and may possibly be before the board, but it would entail me saying that Mr. or Miss X is not doing his or her job because they're not carrying out these responsibilities. So, you know, it had just a couple of other matters. And I would definitely recommend, Judge Prater did a wonderful job pointing out all of the factors that she determined were very important in enjoining the school district from applying the policies as written.
Great, thank you so much. I just want to again thank you for having me today. This was an incredible opportunity to be able to ask these questions that I'm often left pondering myself. So I appreciate it.
Thank you.
Thank you. Thank you for agreeing to join us.
Okay, so we're at the point in the presentation where we'll entertain some questions, and some have been popping up here. Let me scroll back through the conversation pane and see what we can find. First offhand, yes, the session is being recorded. Not sure yet on whether it'll be posted or not. Okay, who brings charges in front of the court, the DA or a private citizen? It would be a private citizen. It's a civil matter. So for, you know, a local municipality or school district, you would go to your county court of common pleas and seek legal relief. And really what you want the judge to do depends, you know, it's going to be fact specific. The judge has, you know, the ability, if they believe that, in fact, the act has been violated, that they can simply tell the agency, don't do it again, or they can void a vote, they can void a meeting, or if it's particularly egregious, they can levy monetary sanctions on the board members. And I should emphasize that it would be on the board members. The agency cannot pay the fine on their behalf. The first violation could be up to $1,000, second violation's up to $2,000. Now, don't get all excited because I can't think of the last time where we heard of a judge imposing monetary penalties. Rather, like the cases that Kelly has emphasized here, the judges have said either you've got to take these votes over again, or we're going to void the meeting, or simply a slap on the wrist and say, look, don't do this again because you've already cured the violation since the time that the complaint was filed. If by chance you think that there is some sort of criminal intent on the part of the board, then in addition to going to the court for the civil side of the complaint, conceivably you could go to the county district attorney and ask them to investigate any possible criminal activity related to the alleged violation. That had occurred, I think it was probably going on 2 years ago now, up in Shamokin, where a complaint was filed with the district attorney, but not with the court for an alleged Sunshine Act violation. The district attorney did investigate, and the result of their investigation was that while there may have been a violation of the Sunshine Act, there's nothing I can do about that, and there was no criminal intent. It was purely a misunderstanding as to the instructions that the solicitor gave to the council. So, if you're purely after the civil side of it, you go to your court and seek legal relief from the judge. If you do think that there's any sort of criminal intent, you go to your district attorney. But again, let me emphasize that there just has not been a lot of activity in this realm. There's not a lot of case law when it comes to the Sunshine Act, which is why, we're punting here with some of the things that we're telling you. And it is purely guidance. It's not a legal opinion. It's not based on case law in any shape or form. What are some other questions here? Yeah, we talked about that. You want to take a shot at that one?
Yep. Are they is the board able to limit public comment specifically only on items listed on the agenda?
I don't think so.
I don't think so either. If they open it up to public comment, it may be determined to be irrelevant, but I don't believe there's anything under the act that limits the comments to just be on agenda items.
Yeah, I'm going to, take a step back and look at this from a 10,000-foot view. A public meeting is really democracy in action. And it's the opportunity for citizens to address their elected officials. So if you've got a setting where the elected officials can intentionally narrow whatever that public comment is, then that democracy really isn't taking place. So in my opinion, and it's free, so take it for what it's worth, is that I think that, if you're an elected official, you're going to have to sit there and take it. If a person wants to complain about the potholes on their street and potholes aren't on the agenda, that's tough, because they have a right to petition their public officials, and this is their opportunity to do so. Let's see, we've got a longer one here, but let me read it out. I understand the emergency declaration is over with my district committee meetings are all virtual since last summer. No one is present at any public location. Everyone is at home. Public comment is virtual. Now this week we have an all virtual action meeting quorum. I believe their policy states that they can hold virtual meetings at will, but is this okay? Emma, there's always going to be exceptions. There's always going to be fact-specific cases, but in general, our policy here, or our guidance here at the Office of Open Records, is that there needs to be some sort of physical component for it to be in compliance with the Sunshine Act. So, I'm painting with a very broad brush here, but I would think the circumstances that you're portraying with your question are somewhat problematic. And I'd suggest maybe having a discussion with your solicitor, to get their take on the specific facts surrounding these meetings and the settings and whether or not you're in compliance with the Sunshine Act in that particular case. And I think that's just good advice for everyone here. Have discussions with your solicitors because they're much closer to the issues than we are. And I think they can provide better advice. Okay, Wayne, so a board written policy can't actually limit comments to agenda only items. What about a nonprofit governing board? There my take would be it's going to depend. If your board is subject to the Sunshine Act, then it would be subject to all provisions of the Sunshine Act, and that standard would apply.
In addition, Section 710 does provide, says nothing in the chapter shall prohibit the agency from adopting by official action the rules and regulations necessary for the conduct of its meetings and maintenance of order. However, it also states the rules and regulations shall not be made to violate the intent of this chapter. And as George has emphasized through this whole, always emphasized and through this whole webinar, transparency is best. And if he wants to talk about the potholes, then let him talk about the potholes.
Yeah. Gerard, but you can limit the amount of time each speaker can take, correct? Yes. That's definitely a common practice, maybe 3 minutes per commenter. It has come up periodically, well, what if we have a hot button issue tonight and a bunch of people come in and they're all wearing the same t-shirts and they all sign up for public comment. There would be absolutely no problem with the chair approaching that group and saying, hey, in order to prevent repetition, in order to hold down how long we're going to be here tonight, would you be okay with appointing a spokesperson? And in this case, we'll give them a little extra time. I think that's reasonable. Also, if a board wants to change the amount of time that they allow every speaker to talk this particular night, they can do that, whether it be by resolution, whether it be part of your rules of governance for your meetings, whatever. I think most of those allow flexibility. And as long as you can make a case that, these rules that we're imposing are reasonable, I think you'll be fine. Okay. Any other questions? I think we're at the back, or we're at the bottom of the
Did we address the person who raised their hand?
Oh, I'm not even sure how that works. Let's take a look.
Let's see.
Oh, wow. Here we go. Okay. From Bryn Moore, at what point does a board member break the law? For example, a non-moderator school board member, not the president, interrupts the public, or muting a member of the public, or asking why a meeting is virtual, or a board member attacks a member of the public's Facebook post that was hard on the school board. Okay, well, the part about the attack, I'm not so much concerned about that. But I think this goes to the points Kelly was making in talking about some of the case law, where if you're cutting off someone during public comment, boy, you're on really thin ice there, and I'd be careful about that.
I agree.
And then what do you do if they refuse to let you speak on items not on the agenda? Do you have to file with the courts? Well, yeah, at this point, there is no central agency or central authority that governs the enforcement of the Sunshine Act. It's what we call a citizen enforced law. So if it's a local government agency, whether it be a city, borough, township, school district, local authority, you would go to your county court of common pleas. If it is a state agency, then you would go directly to the Pennsylvania Commonwealth Court. JG, can the board decide to not allow citizens to yield their time to another citizen? Then that citizen has extra time. Yeah, JG, this came up, I think it was last week. Someone had called the office or emailed, And it was down in, I think, Adams County, where a speaker had what appeared to be previously arranged to have other people signing up for public comment and then yield their time to the speaker so that they could go well beyond the time that was typically allotted. I think this is going to fall on the board and its meeting practices as to whether they allow one speaker to yield to another. You know, in matters of governance, where you're talking about public officials yielding the floor to another, where there are time constraints, like in the legislature, in the Congress, yeah, that's part of their rules of decorum. But for public comment during a public meeting, number one, the Sunshine Act doesn't speak to it. Number two, I think it would be reasonable for the board to decide whether or not that's allowable or not. Okay, another question has popped up from Bryn. What can you do if they do cut you off, mute you? Court of comment, please. Okay, and then Wayne and Ivana want to talk to each other. It looks like they've got
Mutual
same, yeah,
issues.
mutual issue there. Okay, there you go. Glad to help out here. That's okay. That's okay. Any other questions, folks? Now's the time to get them in. We're nearing the end of the hour here, so we want to make sure we've got everybody covered. Okay, are there any legal action which can be taken against a school board member which intentionally misleads the public? You know, obviously that would be a matter outside of the Sunshine Act, and you'd probably want to consult with an attorney as to, you know, what legal remedies, if any, might exist. And it's, you know, obviously it's going to be fact specific there, but it's probably not a Sunshine Act issue. Accessing documents. Okay, I would suggest that you send us an email. First off, and go to our website, Bryn. Bryn is asking about accessing documents. It sounds like this might be a right to know law issue. Go to our website, have a look around. If you don't find the answer, there will be an email account or more than one email account where you can send us your question. At the very least, we'll respond back to your email, but it may also result in a phone conversation where we can try and get you steered in the right direction with your concerns. But we appreciate your concerns with that. Okay, looks like we are pretty much at the end of the questions. Again, Alexis, thank you for your participation. Thank you everyone for signing on and your great questions. Hopefully we provided you with some useful information, and we'll see you tomorrow at 2 o'clock for our next webinar. Take care, folks, and have a good day.
Thank you.